The court is ready to hear argument in 19673, Housecanary Incorporated versus Title Source Incorporated and the Reporters Committee for Freedom of the Press and Houston Forward Times from Bexar County and the Fourth Court of Appeals District.
May it please the court, Mr. Phillips and Mr. Jefferson will present argument for petitioner. Petitioner has reserved 5 minutes for rebuttal. Mr. Phillips will open and Mr. Jefferson will present rebuttal.
May it please this honorable court. This case begins and should end with the language of the Texas Uniform Trade Secrets Act, section 134A.006, which is set forth in Bench Book A that we have submitted. A court shall preserve the secrecy of an alleged trade secret by reasonable means. Here, the trial court used reasonable means to seal 14 documents out of nearly 1,500 exhibits that were presented to the court. All the other exhibits and all of the trial testimony that has been recorded in the reporter's record is open for public inspection. The Court of Appeals improperly substituted its own judgment of what it would have done for the trial courts. It held that the trial court could not modify an agreed protective order, even though that order had contemplated that it would not apply at trial and that the court could modify it either on motion from the parties or its own motion. I hope in my time here to make 3 points. First, TUTSA and not Rule 76A governs the sealing of trial secrets. Secondly, Housecanary's limited use of these documents during the trial did not compromise their trade secret protection. And third, the trial court did not violate any constitutional right of access by sealing these documents. Let me address each in turn. Right after imposing an affirmative duty on trial courts to preserve trade secrets, Section 6 of TUTSA, set forth again at Bench Book A, provides this sentence: there is a presumption in favor of granting protective orders to preserve the secrecy of trade secrets. As shown in Bench Book Tab B, this is not language from the Uniform Act. Texas added this special language about presumption, and it is the only state to have done so. The Court of Appeals majority held that Judge Canellis abused his discretion, not because they didn't contain trade secrets, because everyone admits that they do, but because the parties had agreed to and a judge had signed a stipulated protective order, which is in Bench Book D. That order said that both parties were to comply with Rule 76A in sealing exhibits before trial.
Mr. Phillips, even if we were to agree with your point that the trial court could modify the protective order, which the order itself says, why wouldn't Rule 76A still govern the sealing of these documents except on the points where there's an express conflict with TUTSA, such as on the presumption? Why wouldn't the remainder of Rule 76 in terms of the procedures and the motion and the notice and that sort of thing still apply?
Well, there's 2 reasons. One is a general reason. Rule 76A is just different in almost every way from TUTSA. 76A has an express presumption of openness. We've discussed the expression unique presumption otherwise in TUTSA. 76A puts onerous burdens on a party to seal a document. TUTSA requires trial judges to use their own initiatives to keep those trade secrets secret. Rule 76A.
But what in TUTSA is inconsistent with providing public notice?
The basic instruction of Section 6 of TUTSA is that trial judges shall use reasonable means to keep documents secret. Now, before trial, when you're filing a motion, giving X number of days to the other side, if you want to seal part of those or the other party sees what you filed and they want to seal it, you can go through that process. But in the heat of trial, with each side having hundreds, maybe thousands of possible exhibits, to stop for 14 days and give this notice is something you could do. The parties could do that, but they don't have to. Under TUTSA, the judge can do that. After all, Rule 76A, essentially, if you follow this court's rationale in Eli Lilly versus Marshall back in 1992, requires a party to prove that a document is a trade secret before the language the court used, a properly proven trade secret is an interest that should be considered in making a Rule 76A determination. Now, Tutsa says an alleged trade secret is entitled to secrecy until it's determined that it's not a trade secret. And there's an even bigger reason, which is not in our brief, but it's important. Tutsa controls because the legislature, well, there is a reason that's in our brief, which of course, again, unique among all states. Our Tutsa says that its provisions control over the contrary specifications of any rule of civil procedure. And then Rule 76A, 76A2, paren A, paren closed, 2, paren closed, which is in your bench book at tab C, says that court records do not include documents in court files to which access is otherwise restricted by law. And there are some areas, of course, our family law judges would be very familiar with that. But Tutsa very clearly otherwise restricts access to trade secrets in the strongest possible language. So since 2013, properly reading the rule and the statute together, Rule 76A simply has no application to trial secrets. Now, the concurring justice and both parties make much of the fact that somehow Housecanary did not properly protect these trade secrets. And so they now are open to the world since they were filed, they say, in the record. And therefore, the trial judge abused his discretion in keeping them sealed. But the law is clear that casual references to or brief displays of trade secret information in a public trial is a far cry from putting the trade secret in the public domain.
What makes it Mr. Phillips, I'm sorry, what makes it a casual reference? You all went to trial using these exhibits. You presented them, you discussed them. What do you mean casual reference?
I'll withdraw the word if that helps. Let's go to tab F.
Mr. Phillips, I'm just trying to, you don't have to withdraw the word. I really am trying to understand the nuances using the exhibits.
What I'm saying is that under the case law, a trade secret is not forfeited. It's not given up unless it enters the public domain in such a way that a person who can get financial benefit from it has access to it and can use it. Now, in this case, none of these exhibits were ever flashed up on the screen in their entirety. None were ever read into the record in their entirety. Some of these documents are hundreds of pages long. And the questions about them were basically just picking an example. It's like saying, well, if you have 5 pages of Webster's dictionary, you know the English language. They were not comprehensively put in the open record. And even if they were, the few cases that there are around the nation on this point make clear that that is not enough to lose trade secret protection.
And I can't recall from the record, but were they brought up during the portion of the trial where the courtroom was closed or not? And if you don't recall, I can always look.
Well, some of these were and some weren't. The courtroom was sealed for the source codes of both parties to be discussed with their key expert witnesses. But let me give the court 4 citations, which I believe would be helpful in understanding what it really takes to waive a trade secret. First is Hirsch Diefall versus Nanya Plastics, 174 F 3rd 411 from the 4th Circuit, where trade secrets were inadvertently filed by a party and remained in the public record for several months, but there was no showing that a competitor ever found them there and used them. So they still had trade secret protection. Gates Rubber Company versus Bando Chemicals, 9 F 3rd 823 from the 10th Circuit in 1993. Their trade secrets were discussed in open court without the courtroom being sealed, and the motion to seal the records came after trial. That was held that they were not waived. Religious Technology Center versus Netcom Online, 923 F Sup 1231. Their trade secrets were filed in another case in the public record. The court refused to find in this case they had been waived because there was a motion to seal pending in the other case. And finally, and perhaps the closest case to ours, Uniram Technology versus Taiwan Semiconductor, 2008 Westlaw 11515597 says there is no authority for the proposition that disclosure in open court destroys a trade secret or is unreasonable. Given the lack of any evidence that anyone capable of using the trade secrets attended the trial during the testimony where trade secrets were divulged, there was simply no evidence to hold that they had been waived.
Mr.
Now,
Phillips, the trial court made a finding in its order on the motion to reconsider that the following exhibits contain trade secrets. So should we view that as including an implied fact finding that there was no waiver?
Well, it's more than just the trial judge. The jury returned its verdict, I think on March 13th, 2018, and in answer to question 37, which is found at tab E of your bench book, they found that the owner of the trade secret has taken reasonable measures under the circumstances to keep the information secret. So I think unless you attack that jury verdict, that takes care of before the jury came back. Then after the jury came back, the trial judge at pages 31 to 37 of what we've attached as Appendix A to our main brief makes clear that he instructed his deputy clerk to make sure that nobody saw these records, and the deputy clerk complied with that instruction. So to this good day, except for 2 records that where the information was disclosed in a federal proceeding and we're no longer claiming trade secret status for us, this good day, nobody has seen anything from those other 12 exhibits. So they are still sealed. Nobody contests that they have trade secret information in them. Now, the respondents have a whole bunch of cases that they've cited for contrary proposition. But as you'll see from tab G in our bench book, every one of those cases either doesn't involve trade secrets at all, or it involved trade secrets that were disclosed by the owner in the ordinary course of business, or have some other problem that makes them entirely distinguishable from this case. I now want to turn briefly to the constitutional right of access. The media interveners say that Rule 76A still must govern, despite any provisions that it's been trumped, because, and I quote, if TUTSA purported to overrule the presumption of openness grounded in the First Amendment, it could not survive. This simplistic argument ignores the fact that we don't just have a unitary constitutional right of citizens to see records and that's it. There is a balancing of constitutional concerns here. The general right of the public to inspect records that are introduced in court and form part of a determination of a verdict versus the specific ownership in a trade secret, which this court has held, and TUTSA certainly would make clear, is a valuable and constitutionally protected property interest. That balance has been struck by TUTSA. And it strikes in favor of sealing because trade secrets are, as the 8th Circuit said in Iowa Freedom of Information Council, a peculiar kind of property in that their only value consists in their being kept private. Respondents offered no case to support their apparent claim that TUTSA was unconstitutional or that the First Amendment or due process or open courts in any way require Rule 76A to be followed or require the judge to unseal these documents. As bench book tab H, that's the final tab, shows, every case they cite either did not involve trade secrets at all, or if it mentioned trade secrets, it was in saying that was one of the narrow categories of cases of property interests that were important enough that it trumps any constitutional right of access. This court and the U.S. Supreme Court have never held, by the way, that there is a constitutional right of the public to have access to documents in a civil case. And so that's why the briefs rely extensively on In re Doe, which is a no-writ case from the Houston 14th Court of Appeals. So in conclusion, TUTSA requires trial judges to protect trade secrets, gives them plenary authority to do that. They were trade secrets before the trial. Nothing that happened in the trial or afterwards has compromised their trade secret status, and there's no constitutional right of access that trumps Housecanary's due process property right in keeping these trade secrets.
Mr. Phillips, is there any reason that you didn't specifically request for a specific protective order during trial?
Well, this was a 5-week trial, Your Honor. There were hundreds of exhibits flying around, and there's only so many times you can send the jury out in the hall and tell them to wait. The trial certainly could have been conducted another way, but then we wouldn't have had the pleasure of meeting here today. And nothing that was done or not done makes what this trial judge did an abuse of discretion. So we would ask that the judgment below be reversed.
Any other questions? Thank you, Mr. Phillips. We'll hear from the respondents.
May it please the court, Mr. Keltner and Mr. Babcock will present argument for the respondents. Mr. Keltner will open with the first 10 minutes.
Please the court, the resolution of this case does not turn on the interplay between 76A and TUTSA. While we agree with the media interveners that the two are compatible, we're going to leave that issue to Mr. Babcock. Instead, the resolution of this case actually depends on whether after Housecanary placed these documents in the record, the 8 exhibits in the record, left them there unprotected for 90 days without any type of protection, whether retroactive sealing to restore rather than preserve the trade secrets was appropriate. The answer under the SBO is clearly no. The answer under TUTSA is no as well, because it requires preservation, not restoration. Now, I'm going to cover 2 points. And first is the SBO expressed a fundamental commandment of trade secret law, and that is that secrecy can be destroyed or lost if the trade secrets become part of the public record at trial. Scope paragraph 2, the scope paragraph 2 of the SBO says precisely that. And TUTSA preserves the secrecy as well, again, by preserving secrecy, not attempting to restore it.
Mr. Keltner, on that public record point, they were introduced and discussed. Do they become part of the public record only if there is evidence that the public actually accessed them, or is it just the fact that they were there available for the public at any particular point? I'm not sure how that works.
Let me give you a legal answer and then a factual answer as well. I think coming into the record alone puts them in the public domain. That's actually what this court's precedent has said in the past, and we'll talk about that in more detail in a minute. But the factual issue is a little bit different than Mr. Phillips suggested. The courtroom was not sealed except on 2 occasions dealing with the source code. And by the way, just so you know, Housecanary thought that 76A applied. It shut down the courtroom, filed a 76A motion when its source code was introduced. And by the way, when it first attempted to seal these records, it used 76A as well and the SPO, saying that the SPO applied throughout the proceedings. Not my words, theirs. So the issue is this. Other than that, this was not a closed courtroom. The exhibits were pre-admitted on December 27th, were put in an exhibit book that remained in the open courtroom with people coming in and out. This was a very heavily covered trial, more so, I'll admit, after a significant judgment than before, but nonetheless, a significantly covered trial. So we can't say who saw what, when, and where. The issues regarding telling the court clerk to keep the records close, that happened after the trial, the day before the hearing on May 11th of 2018. By that day, the trial had been over for almost 50 days. So that is the only protection the court refers to. In answer to Judge Busby's question, as a result of that, I don't think there's an implied finding that there was no waiver, or more importantly, whether they could prove that the secrecy continued to exist.
Mr. Keltner, if there was an implied finding of no waiver embedded in the trial court's finding that the exhibits contain trade secrets as defined in TUTSA, is your contention that there's no evidence to support that finding? And what's your best argument on that?
Yes, it is our contention that there's no evidence to support that, and legally it's not sustainable. Let me point to two cases in the court's prior jurisprudence. Paxton versus the City of Dallas. Judge Guzman, your opinion. Interesting case. It was, by the way, it's not a trade secrets case. I don't want to put it on Tom's table that way, but it is not a trade secrets case. It was an attorney-client secret case dealing with the Public Information Act. And the issue there turned on whether there was a compelling reason. The court found it, but the court made some other rulings, and they were terribly important. And they were this: if once privileged information is disclosed, and it was going to be disclosed in an open courtroom in that case, if the order wasn't there, confidentiality, according to the not unanimous court, but the court, was lost for all purposes for all time. Additionally, the court held, if that happens, even if it's inadvertent, and you don't take prompt action to protect that, that's inconsistent and the privilege is destroyed. In this case—
So, Mr. Keltner, is it your position that if we conclude that lost forever for all time happened here, that it will negate the jury's ultimate conclusion that these were trade secrets?
No, Your Honor, we don't take that position. The issue is the damages in this case were prospective in nature. It might cut off some of that. As you know, the underlying case has been reversed and remanded and may be headed to your court. So that's another issue for another time. But the issue is Paxton has something to say about this. It focused on the ultimate issue involved here. And there's a common thread, and that is who disclosed the secrecy. If it is the holder of the trade secret, that is dispositive. And by the way, in In Re Ford, which I will have to admit is not in our brief, I thought it was, or I would have filed a letter yesterday, but it's 211 Southwest 3rd, 295, a per curiam decision from this court in 2006. Same issue came up, and it's very important. It is a trade secret case. It does predate the act, but here's what the court held. Court held, look, when you're dealing with these guys, and here's what happened. Ford was involved in a products case, and it had trade secrets. It got a protective order. Same protective order was entered all over the country. Unfortunately, a clerk in Florida, not in Texas, inadvertently disclosed. So the issue for the court was that a waiver? The court understandably held that it wasn't, but it said something very important. When you're looking at this, what you look is at the quality of the actions and who did them. If it had been Ford who had disclosed them, that would have ended the ballgame and it would have been lost. And in fact, Ford says voluntary disclosure by the holder makes those public, if done in open court, destroys that element of the privilege. Remember, I'm sorry, Your Honor.
Just before you leave that point, in an inadvertent disclosure, if you take steps to protect the documents, then Paxton speaks to that. As a matter of law, are you arguing that taking measures to protect the documents after a trial is too late, just as a matter of law?
Yes, Your Honor. In this case, it is, and as a matter of fact, too, because these things languished there forever. This was an intentional thing too. This was not done inadvertently. These are magnificent lawyers on the other side, all of them, and they're all our friends. But the truth of the matter is they didn't even think they were trade secrets. I disagree with Mr. Phillips. Actually, if you look at page 32, note 2 of their brief, they indicate that one of the exhibits, I think it's 759, didn't contain a trade secret. On the complexity scores, exhibits 561 and 800, at the trial court, they told the court, oh no, those aren't the trade secrets. That's just a PowerPoint about them. I don't think they have even proved these are trade secrets. But nonetheless, we have a situation, to get back to your question.
Does TUTSA require you to prove that they're trade secrets, or are we to afford that presumption even if they're alleged to be trade secrets.
006A certainly says alleged trade secrets, but the issue is it's a definitional problem because 0026A says that you have to take reasonable measures to protect. How in heaven's name is Housecanary now going to do that after not following a protective order that they agreed to? Nothing in TUTSA authorizes anyone to ignore a protective order and not comply with it without suffering the consequences. And that's what we have here. In conclusion, let me just say two things. I'm going to leave you with some undisputed facts. The truth of the matter is Housecanary concedes that this was a, excuse me, that the stipulated protective order was a reasonable means to protect these. Additionally, it also has to admit it didn't comply with it. It received all the benefits TUTSA required. And that's very important here, Your Honor, because what happened is that if it had complied with the protective order, we wouldn't be here today. The truth of the matter is nothing allows a party not to comply with the protective order and without a consequence. Again, if they had complied, we wouldn't be here. Finally, there's only one conclusion. Now, Housecanary cannot possibly prove under 0026A that it took reasonable measures to protect these trade secrets. They talk about general disclosure and reasonably ascertainable, but they have to have reasonable measures too.
Any other questions? Thank you, Mr. Keltner.
Thank you, Your Honor.
Mr. Babcock, we'll hear from you.
Thank you, Your Honor. May it please the court, Chip Babcock representing the Reporters Committee and the Houston Forward Times. I'm here to address what to us is a troubling aspect of the case, and it was personified by Mr. Phillips' statement that this starts and ends with 6A. TUTSA applies to a certain type of trade secrets. I'll call them TUTSA trade secrets, but only trade secrets in an action under that chapter. There are many other trade secret issues that arise, mostly in products liability cases, and I don't think the suggestion would be made that 76A doesn't apply to product liability cases. In fact, back in 1990, when the legislature promulgated Section 22.010 of the Government Code, instructing the Supreme Court to develop a rule that became 76A, the rule, as is the court, as is its custom, delegated that to the Supreme Court Advisory Committee for advice. And there were three public hearings, multiple hearings with the SCAC, and Chuck Herring, the chair of the subcommittee, sent the court a lengthy couple 100-page report. And in it, he said that the intellectual property section of the bar was trying to get trade secret litigation exempted from 76A. Now, another section of the bar is trying to have the same thing done through this litigation. The court back then wisely decided not to exempt trade secret litigation, even though it did exempt other kinds of cases like family law. And we've had 30 years of coexistence between trade secret litigation and this case, which I think everyone would have to agree is somewhat unusual in the way the trade secrets were handled in the court below. First of all, and of course, I want to talk about the supposed conflict. First of all, the suggestion was made in the briefing that somehow 76A is a mere rule and therefore is subservient to Section 6A of TUTSA. That's not true, of course. 76A was dictated by the legislature in Section 22.010 of the Government Code. TUTSA allows, of course, vindication of private rights, but 76A promotes the public interest in openness in court records. It follows a long common law and constitutional tradition of permitting public access to judicial records. It embodies the idea, as Justice Tom Clark said in Shepard v. Maxwell, justice cannot survive behind walls of silence. Justice Douglas in Craig versus Haney said, what transpires in the courtroom is public property. So does TUTSA, because of Section 07, somehow wipe out 76A, which vindicates this public right of this public interest in court records? Well, let's look at the text of 6A, if there are any textualists among us. And the first thing we see is the presumption that the petitioner is relying upon is not a presumption that wipes out 76A. It is a presumption of granting protective orders. So a protective order that is presented to a judge, a motion, he or she will be favorably disposed because of this presumption. But it is not a conclusive presumption. It is not an irrebuttable presumption. It's just something that the court will treat favorably.
But Mr. Babcock, isn't the presumption contrary to the presumption that's in 76A, the presumption of openness?
No, I don't think it's contrary. There are dueling presumptions for sure. And then
wouldn't 007 say that the one in TUTSA prevails?
No, not if they can be read together. And it seems to me that your function should be to read them together. 6A mandates the means of achieving secrecy must be reasonable. Would it be reasonable, for example, if a litigant came to a trial judge, and said, we want to seal all of the opinions and orders of the court? Could that presumption of granting a protective order overcome the express provision of 76A that says those are all public? In most cases, certainly for pretrial discovery, a protective order is going to prevail. For documents, even exhibits in trial that specifically talk about trade secrets, the court can look at the presumption of openness and easily find that there is a specific, serious, and substantial interest, which clearly outweighs the presumption of openness. He may do that, or she may do that, because they're favorably disposed, as they've been told to do by the legislature. But nevertheless, this presumption of openness has got to be a calculus. It's a balancing test. And the court in the Dallas Morning News case, which has been heavily cited by Petitioner, suggests that. In that case, there was a constitutional right of due process. And this court said, no, you've got to balance the two rights, the right of access versus the constitutional right.
And looking at that balance, what material aspects of Rule 76A do you contend that Housecanary failed to comply with in seeking that these exhibits be sealed post-trial?
They didn't comply with any of the procedural rules. They didn't give notice. They didn't have a certain time period. There wasn't a temporary sealing order. In fact, they had complied with 76A all the way up until they lost. And then they switched horses and said, "Oh no, we're going to go on 6A." And their argument was, well, all these other things. If 76A didn't apply, Your Honor, we wouldn't be here. My clients wouldn't be here because 76A grants us a right to intervene. Would we not have that right in a TUTSA case? So those are all the things that I think.
So notice, they didn't give notice to the public or to the news media?
They didn't give notice. They didn't have a hearing with certain time limits. They didn't comply with the temporary sealing order provisions. They arguably didn't comply with Section 6 on the order. There was continuing.
Leaving aside the protective order itself, assuming that there is no procedure in the protective order,
Yeah.
but just applying Rule 76A, are there specific aspects of 76A that they did not comply with?
I think if you read the record, one could say that they did comply by showing a specific, serious, and substantial interest, which clearly outweighed the presumption of openness. I think you could say that. I think there wasn't any health issue here, as there sometimes is in trade secrets. So I think one could argue that they did.
Mr. Babcock, before your time expires, on the issue of the First Amendment and the common law presumption of openness, if we were to read Tutsa to say that the presumption in favor of sealing does displace the presumption of openness in 76A1, is it your contention that Tutsa would be unconstitutional?
I think that 76A there's a constitutional element of 76A. I can't cite you a case that says that there is a First Amendment right to access to trade secret documents. There are cases, and we cited them in our brief, that say that there's a First Amendment right of access to evidence in a trial. And the whole genius of 76A is it vindicates the public's right to know what its decision makers are basing their decisions on. This was a huge verdict in a highly publicized, important case, and the public is entitled to know what it was that went into that decision.
Any other questions? Thank you, Mr. Babcock.
Thank you, Your Honor. Thank you, Justices.
Mr. Jefferson, I think you have 5 minutes.
May it please the court. Sorry for that interruption. The public did know and did have a right to know what happened at the trial, and it was communicated. The press was available. The transcript of the arguments are in the record, and so they can do what they need to do to show the public what happened during this proceeding. Justice Busby, you asked why you would not apply other provisions of 76A. Well, the purpose of 76A notice to the public is so that the public can complain and seek access. But here, Tutsa says the public cannot have access. That's the presumption. Tutsa says the public is not entitled to see the trade secrets. And there's a whole background of this that the business section lays out in its amicus brief. It tells the history. This really was a debate between Justice Doggett in a Texas Law Review article and the legislature. It was Doggett's position that everything should be absolutely open to the public, including things like trade secrets. And the reaction of the legislature was no. Trade secrets are necessary in a state as big as Texas, where there's a competitive marketplace to allow business to flourish. And so they, as Chief Justice Phillips said, wrote in a presumption that is nowhere else to be found in the Uniform Act. Justice Busby, you also asked, is there an implied finding of waiver of no waiver because the trial court made that finding, that there were trade secrets? And I think the answer is yes, there's no waiver because it is a trade secret and it was not shared with competitors by definition if it's a trade secret. There is no opportunity in this case to this date for a competitor to inspect and analyze the material because it's not in the public domain. And the material that we're talking about is their log algorithms, their source code, they're a bunch of computer data bits that go on for hundreds and hundreds of pages. None of that was made available to anyone in the public at any time during the proceeding, from pre-trial, when the protective order governed, to the end of trial, to this day. In fact, the trial court rebuffed efforts of people to gain access to those exhibits and specifically instructed the jury not to disclose any of the information. Justice Bland, I thought you asked the question that is sort of at the heart of this. Who has to prove, who has the burden here on trade secrets? It is not Housecanary's burden to prove there are trade secrets, even though we know they are because of the trial court's finding, the jury's finding, and the judgment in this case. The burden is on title source and the interveners to prove there was no allegation even. Not only no trade secret, but no allegation of a trade secret. And, or in fact, that they were in the public domain in a way that the competitors could access them. And that did not happen here. The documents did not languish in the public record. No one was allowed to retrieve them. Mr. Babcock said there's a wall of silence here. And again, I'll take issue with that because absolutely there was no wall of silence. The record is available and the testimony is available on the, about the exhibits. What is not available is what everyone understands to be the trade secrets here. About the First Amendment, the right of access to court records is qualified and not absolute. That's in the Courthouse News versus Planet case and the Richmond News case. Richmond News is important. It's a US Supreme Court decision from 1980 because this court cited it just a few years ago in M.I. Swacco and cited this specific sentence from that from a concurrence by Justice Stewart, quote, "The preservation of trade secrets might justify the exclusion of the public from some segments of a civil trial." That is true. And in M.I. Swacco, it even meant that potentially the adverse party could be excluded from the courtroom during a discussion of trade secrets. And it is true that the exhibits were talked about in open court, but there is no evidence, and again, this is a burden question, that anyone outside the parties were present in the courtroom at that time. And more importantly, secrecy survives a limited public display that does not provide competitors with a reasonable opportunity for inspection and analysis. That is a quote from the Restatement of Unfair Competition, Section 39, Reporter's Note to Comment F. So in conclusion, the Court of Appeals got it wrong, the trial court got it right, and the trial court adhered to its duty, its separate independent obligation to protect trade secrets from public disclosure. And so we ask that the court reverse the Court of Appeals judgment.
Any other questions? Thank you, Mr. Jefferson. The case is submitted and the court will take another brief recess.